As a medical professional, I've witnessed firsthand the complexities families face when navigating serious illness and end-of-life care. These situations are often emotionally charged, and it's easy to feel overwhelmed by medical jargon and legal considerations. That's why I wanted to create this guide to empower you with knowledge, understanding, and a sense of control during challenging times. We'll be unpacking crucial terms and concepts related to end-of-life care, legal planning, and advocating for your loved ones. From understanding medical terminology. By familiarizing yourself with these terms, you'll be better equipped to engage in meaningful conversations with your healthcare providers, loved ones, and legal representatives, ensuring your voice is heard and your needs are met. A guardian ad litem is a court-appointed individual, often an attorney, who represents the best interests of a minor or someone deemed incapable of representing themselves in legal matters. In the final days or hours of life, palliative sedation can provide comfort by relieving pain and suffering. This also can take patients out of terminal agitation. This is carefully administered by physicians through specific medication regimens. This can be done in a hospital setting or home setting under the care of hospice. Laws regarding end-of-life care vary by state. It's crucial to understand your local laws on driver's license removal, whose responsibility it is to notify your local Department of Motor Vehicles. What are the laws on a carried concealed weapons license? What is your state's look-back periods? This is the time Medicaid will look into your finances to make sure no one is hiding, transferring money. No large gifts can be given during this time, or deeding your home to someone and depositing money from one AC to someone else's. This is important in case your loved one needs to be placed in a facility. Medicaid won't step in financially until all monies are spent down. If you choose to hide money, that is Medicaid fraud. Patient laws protect patient rights, along with dying with dignity options. So, hospice is specialized care focused on providing physical comfort for patients with terminal illnesses, and also emotional and spiritual support for their families. This is usually covered by Medicare, but you must qualify. Each agency has their own requirements. A terminal illness refers to a medical condition that's expected to lead to death. Although, honestly, the time frame isn't always clear and can vary significantly. Terminal lucidity is a phenomenon where individuals nearing the end of life experience a period of unexpected clarity and awareness, often after a period of cognitive decline. Assisted dying or death with dignity is actually legal in some states and countries. If your loved one expresses interest, you need to do your research early and find out which state allows dying with dignity, and also if they allow for a patient with dementia, FTD. Some states and countries will, but it must be dealt with at the beginning of the illness. This is not something you can see a doctor for in the middle of a diagnosis. Patients with dementia really need to make their wishes known early on, since cognitive decline can later limit their ability to consent. A durable power of attorney for healthcare, which is also called a healthcare proxy. This allows you to designate someone to speak for you if you no longer can, sign papers for you, make decisions on your behalf. Frontotemporal dementia, or FTD, is a neurodegenerative condition that affects the frontal and temporal lobes of the brain. There are actually several variants, each with their own specific symptoms. The AFTD.org is a great place to get more information on your loved one's specific variant. Early onset refers to cases diagnosed before the age of 60. Very progressive condition, meaning it worsens over a quicker amount of time. So decisions need to be made quicker. Palliative care provides comprehensive support for patients and families facing serious illness. It's important to check your insurance coverage and local availability to access these vital services. At the time of my loved one's illness, we had zero palliative care in our area. POLST form, or physician orders for life-sustaining treatment, it is a medical order that communicates your end-of-life wishes. It must be signed off by your doctor and a copy to your team of doctors, a copy on your refrigerator, and I kept one on myself. And more importantly, a copy to your hospital. Your doctor should have them, and we did have ours notarized. The POLST form states the patient does not want any care that would prolong their life. It is pink for visibility. If it's not on your person outside of the home, they will do life-saving measures. A DNR, or Do Not Resuscitate Order, is a legal document. It states no medical measures can be taken if your heart stops. It's important for your doctors, loved ones, and hospital has a copy. To cover all bases, I had everything document prepared by an elder attorney, but forms can be downloaded, filled out, and notarized. An advance directive is a legal document that outlines your wishes for care if you are unable to communicate with them. You can create one at home, but I would have notarized. In this situation, our elder attorney prepared my loved one's wishes, but I will be honest with you, the hospital didn't follow his advance directives. So being there in person to make sure his advance directives were followed is a must. 5 wishes. The 5 wishes document is a legal advance directive, also known as a living will, that allows individuals to express their wishes regarding their medical treatment and end-of-life care. It goes beyond medical decisions and includes personal, emotional, and spiritual considerations. 5 Wishes is designed to be easy to understand and use, written in everyday language, and is America's most popular advance directive. Here's a more detailed look at the document. Key features. Legal advance directive. It functions as a legal document that guides medical decisions when an individual is unable to make them themselves. Comprehensive approach. It covers not just medical treatments, but also personal, emotional, and spiritual needs, helping individuals express their values and wishes regarding comfort, dignity, and how they want to be remembered. Who they want by their bedside, any music, massage, special clothing. These decisions should be solely by the patient with the attorney. Easy to use. Written in plain language, making it accessible to a wide audience. Widely used. With over 43 million copies in circulation, it's a popular choice for advanced care planning. 5 sections. The document is structured around 5 wishes. My healthcare advocate, choosing a person to make healthcare decisions when you can't. My treatment wishes, specifying the medical treatments you do or do not want. How comfortable I want to be, expressing your comfort preferences. How I want people to treat me, sharing your wishes for how you want to be treated with respect and dignity. This gives you peace of mind. Completing the document can provide a sense of peace and control over end-of-life decisions. Reducing disagreements. It helps prevent disagreements among family members regarding medical care choices. Respecting individual preferences. It allows individuals to express their unique wishes and values regarding care and treatment. I let my loved one alone with the attorney to fill this out. It was his wishes, not my wishes for him. Again, you can download the forms inking, just please get everything notarized. So, a power of attorney allows you to designate another person to make legal financial decisions, as well as medical on your behalf. Durable medical equipment, or DME, refers to medically necessary equipment and supplies, like wheelchairs or oxygen tanks, ordered by a doctor to assist with your care. Remember, you must advocate for your loved one's needs and your needs to help be the caregiver. For individuals with disabilities, special needs. Trust is crucial. This involves legal and financial strategies to ensure their well-being and access to necessary resources. So money is put aside that no one can touch, unless specified for the patient. An attorney who practices fiduciary representation acts on behalf of a fiduciary, a person legally obligated to act in the best interests of another person or entity, ensuring responsible management of their affairs. In Nevada, the Medicaid spousal impoverishment rule protects spouses from being financially impoverished when their partner is institutionalized. This law, enacted by Congress in 1988 and implemented by Nevada, ensures that a certain amount of the couple's combined resources and income are protected for the spouse living in the community. This prevents the healthy spouse from losing their home and assets due to the costs of long-term care for their partner. Key points of the spousal impoverishment rule in Nevada. Protection of assets. A portion of the couple's combined assets is protected for the spouse living at home, while the rest of your finances will be allocated for the patient's care, paying for senior care. This protected amount is known as the Community Spouse Resource Allowance, CSRA, and it varies based on federal guidelines according to paying for senior care. Protection of income. A portion of the institutionalized spouse's income can also be set aside for the community spouse, according to Medicaid. Applicability. The rules apply when one spouse is seeking long-term care Medicaid, including both institutional care, nursing homes, and home and community-based services, HCBS waivers, according to Medicaid planning assistance. Purpose. The spousal impoverishment rule aims to prevent the spouse living in the community from becoming impoverished due to the cost of their partner's care, according to Medicaid planning assistance. How it works in Nevada. 1. Medicaid application. When one spouse applies for long-term care Medicaid, the state Medicaid agency determines the protected asset and income amount for the community spouse. 2. CSRA calculation. The CSRA is calculated based on the couple's combined assets, with a minimum and maximum amount set by the federal government. 3. Income protection. A portion of the institutionalized spouse's income may be protected for the community spouse's use, according to Medicaid. 4. Community spouse eligibility. The community spouse can continue to live in their home and maintain their standard of living, according to Smart Asset. For more specific details and guidance on this law, it's recommended to consult with an estate planning attorney or a specialist in Medicaid planning in your state. Remember, every state is different, the look-back period is different. Nevada is 5 years, one of the highest in the U.S. Keep receipts of expensive purchases like a new dishwasher. Medicaid can ask for these receipts. I added note on facilities. Look into facilities early with your family member's diagnosis. I found out the hard way, no one would accept his diagnoses. Not one person mentioned this was a possibility. Irrevocable trust cannot be changed once it's created. State ombudsman, public official that investigates complaints from citizens against government agencies and officials. Caseworker, healthcare professional that offers support to patients and their families, getting papers filled out correctly, placement in a facility. Oversees the whole process. Social worker, non-medical support to patient or family members, letting you know options and resources. Hospitalist, in-house doctor that practices at the hospital, not in a private setting. Elder attorney provides legal advice for the elderly, including wills. Trust, they know the laws for your area. Long-term care insurance, all I can say is read all the fine print. Doctor, self-explanatory, but there are doctors that choose specialties, and if you have multiple health issues, you may have a team. Physician assistant. They are not a doctor. A physician assistant, PA, will work under the state medical board. They take continuing classes to keep the license current. They can work without a physician being physically present, but they must have a supervising physician and a practice agreement. The supervising physician doesn't need to be on site, but must be available by phone or other electronic communication. PAs can see patients, diagnose illnesses, and prescribe medications under the supervision of the physician. Nurse practitioner, NP, work under the state nursing board, must have a current license and take classes to keep their license. Full practice authority, FPA, for nurse practitioners, NPs, allows them to practice without physician oversight, including diagnosing, treating, and prescribing medications. They can manage their own practices, lead healthcare teams, and interpret diagnostic tests independently. As of 2025, 34 states and the District of Columbia have FPA, granting NPs greater autonomy in their practice. Registered nurse, RN, works under the state nursing board. They also must take continuing education classes to keep the license current. They can work under the supervision of a doctor, nurse practitioner, NP, or physician's assistant, RPA. The specific roles and responsibilities will vary depending on the state and the setting, but generally, ARN's role includes providing patient care under the direction of a licensed healthcare professional. Here's a more detailed explanation. RNs and physicians. RNs are always under the supervision of a licensed physician or other authorized healthcare provider. The physician's role is to provide overall medical direction and expertise. RNs and NPs. While NPs can practice independently in some states, they often work collaboratively with other healthcare providers, including RNs. In such cases, the NP might be the primary provider, and the RN would work under the NP's guidance. RNs and PAs. PAs also work under the supervision of a licensed physician. While the PA may be able to order tests or prescribe medications, the RN would provide direct patient care under the PA's supervision. In all these scenarios, the RN's scope of practice is defined by their state license and their specific role within the healthcare team. Certified nursing assistant works under the state nursing board. Certified nursing assistants, CNAs, work under the supervision of doctors, nurse practitioners, and registered nurses, physician assistants. CNAs provide basic patient care and daily support, while RNs and NPs oversee their work and assess patient needs. They must be licensed and continue education to keep their license current. Medical assistant, MA. They work under the medical board. They do not have to be licensed or certified, so they do not have to keep up their education unless required by their employer. They can work under a doctor, physician, nurse practitioner, and a RN. These titles are all part of a team that works together for your care, working at different levels. You may also find a nurse practitioner that went to school 30 years ago only went for 6 weeks, whereas today it requires a lot more education. A physician's assistant used to only go through a year program with zero medical background necessary. Now it is much different. A lot more education is required. AMA against medical advice. AMA, in healthcare, refers to a patient's decision to leave a hospital or other healthcare facility before their doctor or healthcare team recommends discharge despite their medical advice. This often implies the patient is leaving before their condition has been fully assessed or treated, which can expose them to risks. Here's a more detailed explanation. Patient's choice. AMA is a patient's decision, not a doctor's recommendation. Leaving early. The patient chooses to leave before the healthcare team believes they are medically ready for discharge. Potential risks. Leaving AMA can increase the risk of readmission, complications, and even death, especially for patients with certain conditions. Informed consent. Before leaving AMA, the patient is typically informed of the potential risks and consequences of their decision. Ethical and legal. While healthcare providers are obligated to provide advice, patients have the right to make their own decisions about their healthcare. Documentation. Patients who leave AMA may be asked to sign a form acknowledging their decision and the associated risks. Not the same as elopement. Elopement or wandering involves a patient leaving without the intent to return. While AMA is a conscious decision made by the patient, you are your loved one's advocate. So that being said, talking to your loved one's team, taking notes, I now record conversations so I don't forget what was said. If you feel your loved one needs something, do not be afraid to ask for it. If you don't like a particular staff member, ask for a new person. If you feel neglect, ask for a social or caseworker. If you feel your loved one is in danger, well, I followed my gut and removed him from the hospital. I felt like I had no choice, and I was right. Speak up. Your loved one's care will only be as good as the communication between you and their care team. The hospital cannot make decisions for you without permission from either the patient or power of attorney. Follow your instincts. Follow your gut. You know your loved one better than they do. You know their wishes, behaviors, and when something is not right, do not let them ignore your concerns. If you have to call someone higher up. Understanding these terms is a significant step towards taking control. By being informed, you can confidently advocate for yourself and your loved ones, ensuring your wishes are respected. Don't hesitate to seek guidance from medical professionals, legal experts, and support organizations. They can provide personalized advice, answer your questions, and help you navigate the complexities of end-of-life care. Remember, you are not alone. Resources and support are available to help you through this journey. Stay informed, stay empowered, and make choices that align with your values and priorities.